more than 480,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer. This is 500,000 pages of paper, more than the last 5 confirmed Supreme Court nominees combined. In addition to not shedding light on Kavanaugh's legal views, the staff secretary documents are very sensitive to the executive branch. Let's emphasize that word, sensitive. These documents contain highly confidential advice, including national security advice, that went directly to the president from his advisors. It would threaten the candor of future advice to presidents if advisors knew their advice would be broadly disclosed. Senators have more documents for Judge Kavanaugh than any nominee in Senate history. Democratic leaders insistent on getting staff documents, I think, was a way of not having this hearing take place at this particular time. So can I proceed, members of the Democratic
Mr.
Caucus?
Chairman, if I may be recognized for 1 final.
After you're done, can I proceed to my opening statement?
I'll defer to my colleagues, but just as a point of information, we sent a letter to you, Mr. Chairman, 7 days ago regarding the committee confidential nature of the documents and asked that they would not be designated committee confidential. As another point of information, it is my understanding there are 6 to 7 million pages of documents regarding this nominee. And it is my understanding, with all due respect, Mr. Chairman, that you've only requested 10 to 15% of the total. I appreciate that there are a lot of pages of documents, but we have to have this conversation in the context of the total and the fact that we've only been given, by your request, 10 to 15% of those documents. My final point is this. This is a hearing about who will sit on the highest court of our land. This is a hearing that is about who will sit in a house that symbolizes our system of justice in this country. And some of the most important principles behind the integrity of our system of justice is that we have due process and we have transparency. That is why we have public courtrooms. That is why we have requirements in courts of law in our country that there will be transparency, that both parties will be given all relevant information. We can argue then as to the weight of the documents and the significance, but not as to whether or not they're admissible. So I object. I ask that we renew and revisit Senator Blumenthal's motion to suspend, or my motion to postpone this hearing. Thank you.
Okay. Thank you, Mr. Chairman. I appreciate the courtesy of the Democrats for me to proceed.
May I just have one last opportunity?
Please go ahead.
My motion. Thank
you.
Please go ahead. I appreciate your giving me the floor. I've made a motion that is properly before this committee. The chairman said earlier that he has never been through a confirmation process like this one. The reason is that no administration in the past has engaged in this kind of concealment. That's the reason, very simply. It is not the chairman's doing, necessarily. It is this administration that has concealed and hidden documents from us and from the American people. And so I renew my motion that we adjourn so that we can access the documents we need, review them in a deliberate and thoughtful way. Much has been done for colleagues in the past when they have requested it, and as is required under Rule 4 of our rules, there is no requirement that we be in executive session to follow this rule, Mr. Chairman. And I respectfully ask that we follow our rules, that we proceed in accordance with those norms. And I know the chairman has great respect for open government, for whistleblowers, for sunlight as the best disinfectant. We need some sunlight in this process. Thank you, Mr. Chairman. And I again renew my motion to adjourn, which has been seconded by Senator Whitehead.
Denied because we're not in executive sessions. I will proceed with
Mr. Chairman, before you proceed, I'd just like to make one correction. There is a misconception as to what White House staff secretaries do. And in fact, two past staff secretaries, Todd Stern and John Podesta, wrote an op-ed in July 30, 2018, Washington Post titled, "Staff Secretaries Aren't Traffic Cops. Stop treating Kavanaugh like he was one." And in fact, Judge Kavanaugh himself has acknowledged the importance of the time that he was White House staff secretary. So why, Mr. Chairman, you and the others on your side keep saying that this was a kind of a nothing kind of a job, nothing could be further from the truth. And this is why we are so adamant about requesting these documents that the judge himself, the nominee himself, has said were among the most formative time of his adult life. Thank you, Mr. Chairman.
Of course, that's why we have this hearing. Judge Kavanaugh.
We don't have the documents.
Judge Kavanaugh will have an opportunity to answer every question about his role in almost anything he's done in his lifetime, I assume.
Mr. Chairman. Mr. Chairman, may I be recognized, sir?
Yeah, will you be the last one, or do you want to go on all afternoon?
I can't speak for my colleagues, but a lot of people I have a lot of respect for on this committee, especially some of the new folks. I just want to answer in the most plain-spoken way I can possibly do. Is we're expected to evaluate a nominee who has a vast record. And if you look, and a lot of numbers have been cited, 10,000 here, 40,000 here, 100,000 here, but in the entire body of his record, sir, we've only have 10% of his record we've been able to evaluate. 90% of it has been withheld from senators, 90% of his record. So we're asking to evaluate a candidate, to have intelligent questions and insights into his record, but we only have 10% of that record. We can go on and on about the numbers of documents, 100,000, 10,000, but the fact is we are about to proceed with a historic hearing. We're about to proceed towards having a hearing on someone having a lifetime appointment on the most important court in the land that will effectuate so many of the areas of American life, from civil rights to women's rights to access to health care. All of this stuff is being decided, and we're going into this only having 10%, access to 10% of the body of work of this man's career. That seems to me just common sense. 90% is missing right now. Just common sense says we should have access to thoroughly evaluate this person. We're not asking for anything out of the ordinary. Other candidates have come before. People can talk about tens of thousands here, 100,000 here, but we've gotten far more for every Supreme Court justice that has been mentioned here, far more than just 10%, just a scan a bit. My colleagues talk about what our duty to the American public is. Our duty to the American public is to evaluate a candidate on their body of work, but we're not even getting released that. And why? Because some political person, not a person who holds public office, not because, I mean, it's unprecedented to think that this committee has ceded its role to a partisan outside lawyer. And so here we're about to go forward with just 10% of this person's record to evaluate, to base our questions on, to investigate. 90% is being withheld. Just common sense would say that that's not fair, that's not right, it undermines our ability to do our job. It is just plain wrong.
One of the Senate's most solemn constitutional duties is to provide advice and consent to the President on the nomination of Supreme Court justices. We're here this week to hear from Brett Kavanaugh, to hear about his exceptional qualifications, his record of dedication to the rule of law, and his demonstrated independence, and his appreciation of the importance of the separation of powers. Indeed, to protect individual liberty, the framers designed a government of three co-equal branches, strictly separating legislative, executive, and judicial powers. The framers intended for the judiciary to be immune from the political pressures the other two face. That is, so that judges would decide cases according to the law and not according to popular opinion. Now, 230 years after ratification, our legal system is the envy of the world. It provides our people stability, predictability, protection of our rights, and equal access to justice. But this is only possible when judges are committed to the rule of law. Our legal system's success is built on judges accepting that their role is limited to deciding cases and controversies. A good judge exercises humility and makes decisions according to specific facts of the case and, of course, according to the law. A good judge never bases decisions on his preferred policy preferences. A good judge also has courage, recognizing that we have an independent judiciary to restrain judges when that government exceeds lawful authority. President Andrew Jackson said, quote, "All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble except guaranteed to them by an independent and virtuous judiciary," end of quote. Confirmation hearings for Supreme Court nominees are a very important opportunity to discuss the appropriate role of judges. As I see it, and I expect many of my colleagues will agree, the role of the judge is to apply the law as written, even if the legal result is not one the judge personally likes. Justice Scalia has often been quoted because he was fond of saying, if a judge always likes the outcome of the cases he decides, he is probably doing something wrong. I don't want judges who always reach a liberal result or a conservative result. I want a judge who rules the law the way the law requires. Judges must leave lawmaking to the Congress, the elected representatives of the people. Judges and justices have lifetime appointments. They can't be voted out of office if they legislate. Whereas if Congress legislates something that people don't like, then you can vote them out of office. That's why they're to interpret law and not make law. Now, some have a very different view of what a judge's role should be. According to this view, judges should decide cases based upon particular outcomes in order to advance their politics. But the American people don't want their judges to pick sides before they hear a case. They want a judge who rules based upon what the law commands. This is the reason why all Supreme Court nominees since Ginsburg have declined to offer their personal opinions on the correctness of precedent. Seeking assurances from a nominee on how he will vote in certain cases or how he views certain precedent undermines judicial independence and essentially asks for a promise in exchange for a confirmation vote. It's unfair and unethical. Indeed, what litigant could expect a fair shake if the judge has already prejudged the case before the litigant even enters the courtroom? I expect Judge Kavanaugh, in fact, it's my advice to him, to follow the example set by Justice Ginsburg and all nominees that followed her, that a nominee should offer, quote, no hints, no forecasts, no previews, end of quote, on how they will vote. Justice Kagan, when asked about Roe v. Wade, said the following, quote, I do not believe it would be appropriate for me to comment on the merits of Roe v. Wade other than to say that it is a settled law entitled to precedential weight. The application of Roe to future cases and even its continued validity are issues likely to come before the court in the future, end of quote. senators were satisfied with these answers on precedent. So, senators should